Welcome back to FDVN's channel. In today's video, we will introduce a new lesson on the topic of structure of a commercial contract. Listen, read, and fill in the blanks. Most written contracts have a similar structure consisting of certain essential clauses, irrespective of the subject matter of the contract. The general pattern of paragraphs can be 1. Heading, for example, distribution agreement. 2. Commencement and date. Usually a commercial contract contains a brief introduction which describes the nature of the agreement, for example, this agreement for the sale of, or this share agreement. Note, the commencement clause will state the date on which the provisions or conditions of the contract are to come into effect. The date is usually inserted in the relevant space. At completion, the last stage in the formation of a contract. 3. Parties, the full details of the parties are set out. In the case of a company, the registered number is included. This remains unchanged during the life of the company, despite any changes of name or registered office. Recitals, also known as backgroup or preamble, these paragraphs are traditionally introduced by the word, whereas, conventionally, key words are in capital letters or have an initial capital. A statement of background facts and the reasons why parties are to enter into the contract. Related or preceding transactions may be referred to. If a later dispute arises concerning the operative part, the recitals may be used to determine construction, that is, interpret intentions. 5. Operative provisions, often introduced by the expression, the parties hereby agree as follows. Or similar words, for example, whereby it is agreed as follows. These words signal the start of the operative part of the contract, containing various clauses which create rights and obligations, or create and transfer interests in property. Operative provisions in more complex agreements may refer to more detail. Schedules. 6. Definitions. This section states the meaning to be attributed to terms essential to the contract. The defined terms. Most defined terms are conventionally given capital initial letters, for example security documents or completion date. In the absence of a definition, words within the contract will be given their ordinary and natural meaning. 7. Interpretation. The aim of this section is to assist in the interpretation and construction of the whole contract by referring to specific uses. There are a number of provisions included in most contracts. For example, words denoting the singular include the plural meaning and vice versa. 8. Conditions precedent. These preconditions must be satisfied in order for the agreement, or the relevant parts of it, to come into effect, for example the grant of planning permission. The conditions precedent clause stipulates, or imposes, obligations on the relevant party to procure the satisfaction of the condition and provide a date by which time the condition precedent must be satisfied. It is usual for an agreement to terminate automatically if this is not achieved by the specified date. 9. Consideration. For a contract to be enforceable, something of value must be given, for example a price, even if it is of nominal value. 10. Other operative clauses, including, for example, warranties, limitation and exclusion clauses, and other standard clauses such as governing law. 11. Schedules, sections at the end of the contract containing specific provisions and documents, for example, the transfer deed in a contract for the sale of land. 2. Practice. 1.1. Decide which part of a contract described in A opposite these extracts have come from. 1. The schedule in 4 parts annexed and signed as relative to this agreement / the buyer shall mean the purchaser of the goods from the company. 2. The consideration for the sale and purchase of the contract shares shall be the net asset value of the company, subject to, plus £350,000 for goodwill subject to adjustment as follows. 3. Whereas the vendors have agreed to sell to the purchaser, and the purchaser has agreed to purchase, the entire issued share capital of Green Boots Limited, the company, on the terms set out in this agreement. 4. This agreement is made the first day of October 2007 between Green Boots Limited having its registered office at 104, Warren Court, Beeston, hereinafter referred to as, the purchasers, of the first part, and Matching Socks Limited having its registered office at 6, Hill Street, Darnley, hereinafter referred to as the vendors of the second part. 5. The masculine includes the feminine and vice versa. 6. The sale and purchase hereby agreed is conditional upon and subject to the following conditions being satisfied on or before the completion date. Sad face I, the vendors exhibiting to the purchaser's solicitors a valid marketable lease in the name of the company free from any encumbrances to the property. 7. The provisions set out in the fourth schedule shall have effect and the parties shall undertake their respective obligations as specified therein. 8. Therefore the parties have agreed and hereby contract and agree as follows. 1.2. Replace the underlined words and phrases with alternative words and phrases from the opposite. There is more than one possibility for one of the answers. 1. In spite of the differences between the parties at the start of negotiations, their intention was to form an agreement. 2. We, the parties, in this way agree to purchase the contract shares. 3. If a dispute arises with reference to the satisfaction of the preconditions, the purchasers may cancel the agreement. 4. Without the specified documents, the agreement cannot come into effect. 5. Terms denoting masculine references include female and the opposite.